Thank you very much for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. It is great to be here today to talk about the National Interest Waiver. And the National Interest Waiver is a green card category that is an excellent option for moving from a non-immigrant visa to a green card, or if you just wanted to obtain a green card and meet the requirements, it's also an excellent option. Before we get into the details, just a few housekeeping items. This webinar will be recorded and we will post the webinar on our YouTube channel. And we do encourage you to sign up to the YouTube channel to subscribe because we do regularly post videos there and informational videos on immigration and other matters. So definitely sign up so that you get the notification. We will send you a few things after the presentation. We'll send you that link to the YouTube channel. We'll send you a copy of this PowerPoint presentation. And we'll also send you a National Interest Waiver guide. And finally, we'll send you a link where you can set up a consultation if you like. We do hold webinars regularly. We have a couple of webinars every week, so definitely go to our webinar sign up page and sign up at your leisure. And the final thing is, if you do have questions, please add them to the Q&A box or the chat function. We will get to all questions. Okay, so without further ado, let's move to the National Interest Waiver, and just what is the National Interest Waiver? So, as I said before, it's a green card, so it's not a non-immigrant visa. It is actually a permanent residency in the United States. And really, the government is taking a look at the person, and they're taking a look at the person's endeavor, and the endeavor is really what the person says that they're coming to the United States to do. And they're saying that what they're coming to the United States to do is in the national interest, and as a result of it being in the national interest, they feel that the person should get a green card. So that's in essence, and there's specific criteria that we look at to make sure that the person meets that, but that's in essence what is going on. And it is a subset of the EB2 criteria. The EB2 has the two kind of offshoots. One is a company sponsoring you for a green card, and the other is National Interest Waiver. So before you look at either of those two, you do have to meet the threshold requirements that we're going to go through in a bit more detail in one of the next slides. But the other category really is company sponsoring you for a green card. And the reason that that exists is because the government has said that they believe that it is in the national interest to protect U.S. jobs. So they make people, when a company wants to sponsor someone for a green card under EB2, they do make them prove that they can't find a qualified U.S. worker. However, the National Interest Waiver, what is being waived is that requirement to prove that you cannot find a qualified U.S. worker. So that's where the waiver comes from in that. So the National Interest Waiver does have a three-pronged test, which we're going to spend most of the time. That test is based on a case called Danasar. And you don't have to have an employer for the National Interest Waiver, so you can actually self-sponsor, self-petition. And the other kind of key thing to keep in mind is that the National Interest Waiver is not, it's never just a profession, right? It's what you're looking at here is you're looking at the proposed endeavor. So the first kind of thing that we look at before we even start a National Interest Waiver is what is the person's proposed endeavor? What are they coming to the United States to do? And we start from there, and then we see if we can move through the different requirements. So we talked earlier about threshold requirements. So before you move to the EB2 category, so that's both the PERM, that's company sponsoring you for a green card, or National Interest Waiver, you have to have one of these, and it's or, right? So if you have one, then you don't have to, then you can move to step two. But this is the easy part. And one thing I will say is that people often get confused and think that the National Interest Waiver requirements have to do with this. And once they meet these requirements, that they can get National Interest Waiver, but these are just the threshold requirements that relate to either PERM or National Interest Waiver. So in essence, either of the two EB2 categories. So you have to have either an advanced degree, so that's a master's degree or higher. And if you have that, no problem. You have an MBA, no problem. If you have a master's in something, no problem. Or you have a PhD in something, no problem. Then you can skip to the next slide. Or if you don't have a master's degree or higher, then you can still qualify if you have a bachelor's degree plus 5 years of experience. Now, keep in mind that the bachelor's degree and even the master's degree, they have to relate to what it is that you say that you're coming to do. So you can't say, okay, I have a master's degree in psychology, and I'm coming to the United States to do a tech startup, right? That doesn't work. And the master's degree and the bachelor's degree and the 5 years of experience all have to relate to the proposed endeavor. Sometimes they don't have to relate directly. Sometimes you can make an argument that it does relate, but they do have to relate. And then, but let's say you don't have a bachelor's degree and you don't have a master's degree, can you still qualify? Well, yeah, let's say you just have a high school degree. You can still qualify if you meet 3 of the 7 exceptional ability criteria that are listed on this slide. And I'm not going to go through these in a lot of detail, but suffice to say that it's definitely better to qualify under one of the first 2 categories, because the third exceptional ability is going to be very difficult. But again, all this means is if you qualify under exceptional ability, all it means is that you move now to the actual hard part, or the requirements of the Danasar test. So what are those? So the National Interest Waiver requirements, the first requirement is that your endeavor has to have substantial merit and national importance. And the substantial merit has traditionally not been the more difficult one. We had a lot of teachers that were coming saying that they should get National Interest Waiver because there's a teacher shortage. And the appeals cases, when they were denied and they were appealed, the appeals cases did say that although the work that the teachers did, it has substantial merit, but they felt that the national importance wasn't there, in the sense that if it was one teacher that was contributing to teaching students over time, that wasn't significant enough in terms of the impact of the overall economy or the overall United States, if that person didn't get the National Interest Waiver. And they also point out that there is a process for people to get sponsored for green cards under the regular EB2 category. So once you look at the endeavor, you have to determine whether or not it has substantial merit and national importance. And the national importance is what we'll focus on. So first and foremost, just doing work related to your occupation is not going to work. So it can be a very important occupation. It can be you're a pilot. It can be you're an engineer. It can be you're a doctor. But just kind of doing work is not going to be sufficient. You're going to have to really show that what you're doing is important to the United States, and not just from a profession perspective, but the actual impact. So let's say, while a National Interest Waiver for a pilot won't work, someone who is starting an aviation school where they're teaching a novel new flying technique or implementing safety standards that are going to be used across all airlines, that could work for an NIW, because we're always looking at, is there something that the United States is looking at as, oh, this is a problem, and this endeavor is actually proposing the solution. The geographic focus is not necessarily important. It doesn't mean that you have to impact every state anymore. You could be doing something that's important, like, for example, creating jobs in an economically depressed area, and that could just be in one state. But what we're talking about here is the ramifications are large. So that, often when people don't meet this first criterion, it's because the government feels that what the proposed endeavor doesn't have the significant ramifications, or the ramifications are not significant enough to warrant that they've met this particular criterion. The other kind of thing to always keep in mind is when, I said that you can self-sponsor, but a lot of the time, or sometimes people will get their employer to sponsor, and the benefit has to go beyond the immediate employer, or the clients of the employer, because the benefits, if someone says, oh, well, I'm working for this company and I'm creating this, economic benefit, the company's doing well, I'm a great salesperson, that's not, likely not going to be enough. But if someone's saying that I'm working for this company and I'm, responsible for running this project where we're developing this cure for XYZ, and that cure is then going to be rolled out to other people in the nation, then certainly something like that could qualify. And we just had an approval just the other day where the case had to do with just economic benefit. So the person had a number of businesses, 5 or 6 businesses, and had over 60 employees. And our argument was that the economic benefit associated with that was important to the United States, and we were able to make that argument successfully. But again, past results don't predict future outcome, but we were able to make that argument successfully because the businesses were things like restaurants and car washes and things like that. The other thing to kind of keep in mind is the job shortages in an area doesn't mean that the government feels that that rises to the level of national importance. We've seen this with teachers, pilots, and the appeals cases have consistently reiterated that you really do have to look at the endeavor and the impact to all of the United States. The second criterion has to do with the applicant being well positioned to advance the endeavor. Now, keep in mind that the endeavor definition has to be grand or should be grand so that it meets criterion number 1. But then we move to criterion number 2, which moves away from the actual endeavor and moves to the individual and their individual's ability to be able to succeed with respect to this particular endeavor. And here we're going to be looking at their background, their education, work experience, etc. But the government usually wants a lot more. They want to see a track record of success, your influence in the field, to say, hey, they've done this particular thing in their home country already, and now they're coming here to do it. Intellectual property can be helpful, like a patent, and how far is the person along with respect, like the example I used about the entrepreneur. We were able to show tax returns, show payroll information showing that he's already created jobs. So we weren't just making a generic claim that he's going to create employment. So that's all going to be very important. So this definitely is not just going to be based on your educational experience and background. They really want to see that you have advanced this or are going to be successful in the endeavor. And then the third criterion has to do with the government has already said that they feel that the protecting U.S. jobs is in the national interest. So this one really looks at whether or not coming up with all the arguments of why the person should be given the green card in any event, right? So we often use a lot of the arguments from prong 1 and prong 2 here, but also we might use arguments from the EB1 criteria or the exceptional ability criteria, which show why the person has risen to the top of their field, to show that why is it a good idea for them to make an exception for this person and give them the waiver. So and some of this we talked about already, that but I think it's worth reiterating that you'd have to look at the specific endeavor and not the field or occupation. I can't tell you how many people set up consultations that they say, hey, I'm a chemical engineer and I should get national interest waiver, but that's not enough, because you have to look at what the person is coming to the US to do. Everything starts with the endeavor. Expert letters can be very important with describing national importance, because someone has to explain to the examiners why this is important to the government. It could be that the national importance is explained through the government actually has pronouncements, like let's say they say that cybersecurity or things in the STEM field are very important. That could be something. Experts can talk to these things as well. And letters from government officials are often very, very useful. So we always, strive to include those as well. And so let's take a look at a couple of examples. Like a person developing drug for pharmaceutical company may establish national importance by demonstrating the prospective health benefits of the drug, right? So that could be a good example of a national interest waiver case. And of course, then you'd want to focus on those widespread benefits rather than focusing on what the benefit is to the particular employer. And it's similar with the next example about spreading out technology. And then job creation is one that we talked about as well. And in particular, if you can show that the job creation is impacting areas that have some issues, like whether high unemployment or economically depressed areas. So what do you include in an NIW submission? So first and foremost, you address the threshold requirements. If a person has a master's degree, you include that. And again, that's a master's degree, PhD, or whatever it is you're including. It has to be related to the actual endeavor, or like an MBA. It's fine if you're doing any type of business thing or even a startup, a tech startup, even if it was in a different field, you can say the MBA is related. But again, if the person has a bachelor's degree in graphic design and 5 years of progressive experience in graphic design, and then they're saying that they're going to do a startup which is going to create a vaccine, then they might not be able to prove the actual threshold requirements under EB2. You're going to include news articles, or if there's other research or academic journals or papers, media sources that show or prove your point with respect to why something's important, government information with respect to data or statistics. For entrepreneurs, if you're showing economic benefit, or if you're just trying to explain what it is that you're doing, a comprehensive business plan could work to show exactly what you're doing. It could work to show how you're going to how you're well positioned to succeed. And expert letters are often, usually we have around 6 or so expert letters. And you first look at what it is you're trying to prove. It could be that you want an expert letter to talk about the national importance. It could be that you want an expert letter to talk about the person's well positioned to advance the endeavor. Sometimes they'll talk about both, but expert letters usually are included. You're going to have the information that's relevant for degrees and proof of accomplishments, et cetera. So all of that's going to be relevant. And you can't just say that when you're looking at the person's well positioned to advance the endeavor, and let's say that you are saying that you want to let's say the person has done it in their home country before. You can't just say it. The government's not going to just take the lawyer's word for it or their word for it. The expert letters might be evidence, but actual objective evidence. If they started a company that did X, Y, and Z, you want newspaper articles, you want the articles of incorporation, you want the tax returns of the company to really show that they've actually done everything that they said that they actually did, and show the past successes. If you are, the example I used where we obtained the approval based on economic benefit, we included a lot of information on the tax returns, the contracts, the letters of intent, everything that we could to show that this business was as far along as it should be, and that it was going to expand. In that case, we actually ended up getting an economist report as well. So that was very, 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 very helpful. A few recent trends with National Interest Waiver, definitely a significant increase in filings, and with that, a significant increase in RFE and denial rates, unfortunately. So you really have to hire an attorney that knows what they're doing, because it is a very, very difficult and complicated area. There's policy guidance that's been implemented. I think it came out just before the new administration started. No big changes, I think. I think it codified some things that certainly our firm always thought were there. I think that we definitely have entrepreneurs that we do national interest waivers for, and sometimes you can focus on the media attention that they're getting, any awards. Have they been selected for a particular incubator? Have they gotten investment from investors, especially recognized investors? Have they gotten any interest or letters from government agencies? Have they already started to bring in money? All of those things are going to be useful if it's a tech startup. Do they have patents or other intellectual property? All of that is going to be very, very useful. And similarly, when we're looking at the well-positioned, we're going to look at, has the person owned a company before in their home country? What do they bring to the table? What's the media saying about them? And, all of these things are really getting at their past track record. So timing for this, you can file an I-140 petition for, well, the petitions that you file is I-140 petition, and if the category is current, you can file an I-485, but it's not current right now. And what current means is that the government can only issue a certain number of green cards per year per country, and right now the EB2 category is delayed by about a year and a half. So you can file the I-140 and you can get an answer quickly. You can pay the government $2,800 and get an answer in 45 days. If you do get an RFE, a request for evidence, or no notice of intent to deny, you answer, and then they have another 45 days. And yeah, so it's most people do premium process national interest waiver petitions, and with the influx of petitions that they're getting, and I think the problem is, one of the reasons that you're seeing the increase in denial rates is because some of them are poor petitions. We get people who set up consults with us and they say, hey, another attorney told us that this is a good NIW case and it's a terrible NIW case, right? So I think sometimes attorneys may just want people to file with them and file, but definitely NIW cases need they're very special cases and can be very difficult cases. But if you have a good case, they're an excellent option for obtaining a green card. If you do have an underlying visa, you want to visa status, it's a good idea to maintain that. And it's the only way that you can continue working in the US unless you file the I-485 and file the work authorization and travel authorization. So that's something to keep in mind. And when you're doing this, you have to make the decision of whether you're going to adjust status or do consular processing. And that's really going to depend on your own personal situation. Like sometimes we had one client, for example, he had an excellent NIW case, was approved right away, but we do have to keep on renewing his it's O1 because he is doing consular processing and he still wants to be able to come back and forth to the US, and the O1 is a quasi-dual intent visa, because he couldn't be in the situation where he was stuck in the US without being able to travel for 9 months to a year. So let's take a look at a case study. This is a case study. It actually is a person who applied through USCIS and was denied, and it was an entrepreneur who formed a small, and I stress small, it was a small in his business plan and small consulting firm focused on improving services to US vets. And when he submitted it, they denied the petition, and then he found a lawyer to appeal, and it went to the appeals board. And so it's an excellent case that we use all the time to discuss what the actual law is with respect to this, because the appeals board said he was eligible and said that he met this substantial merit and national importance. He said that they said that he submitted media articles, research reports on government initiatives. He had other letters from experts in the field. He had a business plan that talked about what he was going to do and his plans to improve the issues that he saw, and letters from people showing that there were actually issues. And he had background in this. He had, again, letters from government officials that said, yes, they would use his services and things like that. And because he was self-employed, the government says, the Danasar says, that this third criterion really doesn't apply when you're looking at for entrepreneurs. So it's just a quick case study. But another point with respect to that is we focus very much on cases when we do NIW petitions, because it's a great idea to quote the case law with respect to these petitions. Perfect. So that's all the prepared remarks, and there are a couple of questions here. I'm just going to take a look at them and read them. And okay, so I was a water resource engineer, and I was thinking that my proposed endeavor could be developing green infrastructure and nature-based solutions for flood mitigation, stormwater management, and design of resilient urban infrastructure. Climate change is a big part of this. Is the area of climate change still a matter of national importance currently? Well, I think so. I think maybe not as much as during the last administration. I don't know if I'd phrase it just as climate change, but just say that you're dealing with these issues, because everyone would agree that those are big issues. I think that the kind of key thing to keep in mind, though, is that I think that while the endeavor itself, like that description of that endeavor, could work, but then we have to move to part 2, right? And we might still be at part 1, but move to part 2 says, okay, well, are you well positioned to advance the endeavor? And the it wasn't clear to me whether the person was saying they're going to start a consulting company or whether they plan to work for somebody else. If they were suggesting that they're starting a consulting company to advance all these things, part two is where a lot of NIW petitions get killed, because they have to show that they're well positioned to advance the endeavor. And you can't just come up with lofty ideas. They want to see that you've done it before, and not just that you've worked in the field before, because that's not going to be enough. Because if you said you're going to work for someone else, then they might just say that maybe you should just get that person to sponsor you for a green card. So it's definitely something to keep in mind. The next question, how unique does your proposed endeavor have to be? Does it need to be something completely new? Can it be the use of existing best practices or techniques to address a particular set of challenges of national importance with other people engaged in similar endeavors also? I think that new and novel, it makes for a better argument, but it doesn't have to be. But I think that the issue is, I think that when it's not new and novel and other people are doing it, then the government has more of an argument to say, well, why are we giving you a green card, right? Like, like, how is this in the national interest? Next question, can I apply for NIW if I have a postgraduate degree but no job offer? You don't need a job offer to apply for NIW. It's you can self-sponsor. How can you travel during the 9 to 12 month period waiting for a green card? Can you elaborate? Okay, so when you apply for an NIW, when you file the I-140, you can certainly travel if you have underlying visa status and ability to re-enter the country. Let's say the category was current, and you file the I-485 at the same time. And this happens anytime you file an I-485. You have to, or you can file work authorization and travel authorization documents. But the travel authorization document has to be approved before you can travel. And that sometimes takes 9 to 12 months. So if you left before that, the petition would be abandoned. But you could do consular processing, like the example I mentioned with that other gentleman. He had an approved I-140, and he did consular processing, and then he had a concurrent O that we were doing for him, and the O allowed him still to go back and forth. When I said my business plan, when I send my business plan, should I also include the source of the money? In other words, do I have to prove that the money is coming from the country? No, so that's not relevant for, just let me read the whole question. Do I have to prove that the money is coming from my home country and from my savings, gifts, etc.? So that's not relevant for this particular visa category. That is relevant for EB5, but not for and for E2, but not for NIW. Okay, I think that's it. I think that was all the questions that we had for today. Thank you very much, everyone, for joining us. And as I said, we'll send a National Interest Waiver guide. We'll send a link to the YouTube page, and we'll also send a link where you can set up a consultation if you have additional questions. Thank you.